Welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is James Quillinan. Jim is an attorney and shareholder with Hopkins & Carley in San Jose, where he's the chairman of the Family Wealth and Tax Planning Department here in California, San Jose. He's been practicing law since he graduated with his law degree from the University of Santa Clara, another one of those SCU people, here in 1974. He's highly respected in the legal community, frequent lecturer and author for the State Bar of California and continuing education of the bar. He serves as special master and referee in Santa Clara County and San Mateo County Superior Courts in complex trust and probate matters. Jim loves to go to the movies.
It's true.
His movie reviews are very popular, and you can sign up to receive them by email for free at www.hopkinscarley.com. Today, Jim and I will be discussing the changes in the Fiscal Cliff tax legislation, which was passed on January 1st, 2013, and the name of it is American Taxpayer Relief Act of 2012, and we're going to be talking about its impact on estate planning. Now, before we get started, I caution, as I usually do, that this is just an introduction to complex issues to help become aware of them for a further discussion with an attorney or other tax advisor who's familiar with them. And the items that we're discussing are complex, and there may not even be any solutions to some of these things yet, because there's going to be regulations issued and many cases that are going to come out over the years and so forth. But anyway, I think we're going to have a really fun discussion here. Jim, thanks so much for joining me today.
My pleasure, Mike.
Now, folks, also I'll let you know, Jim does like a big update for the attorneys here in the various bars in the Bay Area. So he's fresh off of one of these updates. So he's all boned up on this stuff and ready to roll. Okay, Jim, so what were some of the significant changes in this, we're calling Fiscal Cliff because that's what everybody knows it as, tax legislation related to estate and gift taxes?
Well, the most interesting thing is they did get right to the cliff. I mean, it happened technically after the old act expired. They did it on January 1st. But what they are they've taken the tax laws and everything is now more or less permanent, moving from 2013 forward. And really all they did was take the estate tax laws that we have used for the last couple of years, from 2011 through 2012, and reenacted them. They technically repealed the repeal, and then the only thing they did was they changed the effective tax rate for gifts and estates from 35% to 40%, but they did lock in the exemption plus inflation factors. So the exemption that everyone was working with through 2012 was $5,120,000 per person. That has already escalated for this year to $5,250,000 as the exemption for both gift and estate tax. And the interesting thing is if you have a computer program that of course we do in our office, and you factor in the inflation amount over the next 10 years, it almost doubles the exemption to close to 10 million. So the exemption is really quite large compared to what it was. When I first started practicing law, it was $80,000. And now we're up to $5,250,000. So it is there. It is now permanent. It applies not only to the estate tax, it applies to the generation skipping tax, and of course for the gift tax. Now, these are all federal taxes.
Right.
For those of us in California, there is no California state gift or generation skipping tax. So we don't have to worry about it other than the federal level. And as I mentioned, the new flat rate is 40%. Once you go over the $5,250,000, the next dollar is taxed at 40%.
Right.
The other thing that they made permanent, which was really a nifty new feature in 2011, was what is called portability.
Right.
And that basically means that a spouse can leave his or her exemption to the surviving spouse. So collectively spouses would have $10,500,000 of exemption. So a spouse, without creating anything special, can just say, here, honey, here's my exemption. You may have it. And so in the hands of the surviving spouse would then have a $10,500,000 exemption to apply to their estate. So that was kind of neat. Let's see, some of the other things. There were some other things that would have happened if they hadn't repealed the repeal. There were surtaxes, exemptions going down. All these things just disappeared. So the amendment itself was actually quite simple, but it did for the first time in since 2001. Has given us a permanent estate tax that at some point does not have an automatic repeal. So in that regard, we can more or less plan with some certainty moving forward for our clients.
Yeah. So is it, as a practitioner, an estate planner, I think you will agree with me. I mean, that we all sort of had a sigh of relief when this happened, because we've been doing planning and sort of like wincing, like, we're hoping that this is going to hold up, and we were trying to create flexibility and other things, which was necessary. But anyway, it's a good feeling to have, this nice large exemption. It lets most families out from being subject to estate tax. And so, so anyway, it is a good feeling. Now, you mentioned the portability, so I'll mention to our viewers that we're going to do a special program on it. So it sounds nice and simple when we talk about it, in a brief summary, but it's actually kind of involved, and I think it's worthwhile having a bigger discussion about it because, well, for one thing, it's new. It was only created, a couple of years ago. And so we were sitting here wondering if we were going to continue even to have portability. Now it's here to stay, so I think it's worth having that discussion.
Yeah, we'll talk about that in another program, but
Right.
it is a very, very powerful estate planning tool, but it has its pros and cons. So.
Yeah. Okay, well, gee, I mean, you as much as any attorney that I talked to was saying that the end of last year was insane, that there was a lot of heavy gifting that was going on and so forth, and people were making these transfers. Well, did those people really accomplish anything when they made those gifts, now that we've had these changes and so forth?
Well, yeah, I think the people that did, and certainly in the November, December time frame last year, we were probably as busy as we've ever been making gifts, and most of our clients that were making the gifts were maximizing it. Husbands and wives going to the full 10 million, individuals going to the full 5 million, and we were usually doing a combination of things, because not only were they taking advantage of the exemption, taking advantage of what we call discount planning.
Right.
So they were able to make gifts in terms of the true underlying value of the assets even greater than 10 million. And we lost track. I mean, it was just a blizzard of activity for us through the end of the year. There were a couple of things that, obviously they made the gifts, which they should have made anyway. Most of these clients were, they have significant worth. They frankly aren't going to miss the 10 million. They've not only got the 10 million out, we leveraged it, and they got the appreciation of those gifts out of their estate for the
So any future appreciation now will not be taxable.
Any future appreciation is also out. And we even had some clients that actually decided they wanted to go over the limit and pay some estate tax, and they got kind of a bonus, or probably a gift tax. They paid a gift tax at 35% instead of 40%,
Right.
Which would have been this year. So they did. They made gifts, which they probably were motivated to make anyway. But with the uncertainty of where the tax law was going, they were sort of super motivated to get it done. And they've set up structures for their families. When we make these discounted gifts, we're using limited partnerships and LLCs, which is structures for management of these properties. And so, yeah, in the long haul, I think they're all going to, be glad that they did it. at least from our attorney perspective, all the admonition, or what we elegantly call the CYA letters we sent to the clients about how it may or may not work, aren't a problem anymore, because it, in fact, the system is solid moving forward, so we're okay.
Okay. Now, in those final months or the last year or so, and we're speculating, of course, about what would happen if this thing didn't get extended. And one of the issues that we were talking about was clawback, and basically it was that if in fact, again, we went back to the former exemption, former tax rates, and so forth, that these items may be in some way includable in an estate as a previous gift added back in. And so now suddenly a tax would be created at the death of a person that previously made a big gift or something like that. So has that clawback issue been resolved?
Well, it was not so much resolved, but rendered moot by having the gift tax exemption and the estate tax exemption be reunified at $5 million, and not have the problem of having a taxable gift come back on a later death and generate a tax. In the worst of all possible worlds, it could generate a tax on a different beneficiary who didn't get the benefit of the gift. So the clawback issue, and I was one of the people that thought it was real, because if you in fact applied the laws that existed, it happened. And there was people that said, well, gee, this was an unintended consequence, and it probably wasn't going to really happen. But we'll never know now, because it didn't happen by virtue of what happened. But this was one of our admonitions to the clients, was this clawback problem as a potential downside, because of all of it. It could potentially have generated a $2+ million tax that was unintended. So,
and now there may be still an issue, I would think, related to that. Again, as you said, some people paid 35%, and if they haven't included in the estate, we may have a 40% tax.
well, yeah, they may. I mean, that is an issue, because if they in fact paid a gift tax at 35% and it comes back in, and it's going to disappear within 3 years, because the additional tax that would be drawn back in is not going to be an issue after 3 years. So if you can survive 3 years, that little problem goes away. But that's a manageable problem. A 5% additional tax.
So, folks, we don't need to pull the plug anymore. We can sort of hang on, and but there's not many people, again, that are going to be in this spot. There's just a handful that have these.
Because not a lot of people paid the gift tax. I mean, we were using formulas to hopefully avoid that, but I had a few clients that just decided that it was more prudent to go over a little bit, pay a gift tax. And that would kind of lock everything in even maybe a little bit better. But so in any event, I don't think it's going to be that big an issue, but it is out there.
Okay. So another thing that people are going to wonder about is, gee whiz, $5 million, $5,250,000. I'm not going to have to deal with this estate tax. So do I even need to do estate planning?
Well, I think absolutely. The main issue here is that it's called estate planning, and unfortunately most people have thought about it as tax planning.
Yes.
And now what's happened is the tax issue is kind of, gone away. And the old saw used to be, don't let the tax tail wag the dog.
Right.
And that's where we are now. We're back to, what do you want to do? What is your goals? What do you want to accomplish by way of an estate plan in terms of providing for spouse and children, and making sure those wishes are carried out the way you want them. And we're not necessarily having to build a tax structure that might drive you into different scenarios, different methods. So the tax structure is secondary. Now the real planning is important, because especially as lots of people have, they got a second marriage, may have children. You might have children from three. You could have, his, hers, and ours children.
Yes.
And how are we going to deal with all that? And that's the real part of the estate plan, is to set up the proper kinds of trusts to make sure that the spouse is well taken care of, the kids are taken care of, and you can avoid the war that might erupt between them by proper planning.
Right, so try to
it's
reduce those family conflicts.
Yeah, that's the key part. I think we're back to doing the real planning now, as opposed to having to, in every instance, which we did for so many years, you had to have a bypass trust to capture the exempt amount. You had to have a Q-tip trust to catch the marital deduction amount. Those aren't necessarily absolutes anymore. You've got lots of variations. My admonition to everybody that are doing plans out there is flexibility. You can use these trusts, built-in flexibility. You can use powers of appointment. You can use disclaimers, which is a technical device that we lawyers can set up that will allow clients to achieve their goals in a very flexible way. Because who knows what the future holds? You may have children that all of a sudden have special needs, or grandchildren that have special needs, or you have somebody doesn't need the assets anymore, they've won the lotto or something, and you can build the flexibility to deal with these kinds of unforeseen circumstances in the future.
And then one of the new things that I've mentioned from time to time that's providing sort of the ultimate in flexibility is a trust protector. Yes,
we've used those a lot, and now there's even more reason. This is somebody outside of the family, a third party, who can pull the trigger on a different approach to the plan, can create that special needs trust, can extend a trust for a child who may need protection from him or herself. Trust protectors work quite nicely.
Okay. So we have limited time, so we're just going to keep moving here. How permanent are these changes?
Well, they're as permanent as anything can be in terms of the government and how things change. But at this point, there's at least no automatic repeal, which we've been living with for the last since 2001. So now, in order to change it, it would require the normal course of events. There'd have to be a bill that passes the House, the Senate, and gets signed by the President. So it is a little bit unlikely, but I'm always like to remind everybody out there, the system that we have now basically started in 1981 when Ronald Reagan was president. And Ronald Reagan was president for 8 years, and 8 years in a row we had a Tax Reform Act. So you never know. They can change it a lot, but the basics of this system has not changed since 81. The exemptions have gone up, and some of the flexibility issues have gone up. But we're pretty much, using the same techniques that we were doing in the early 80s. We're still using, just with much bigger exemptions. And an interesting statistic I read somewhere, and that is that if they had in fact indexed the exemption that existed back in 81, 82, it'd be about where it is now. So,
isn't it amazing?
And that's the staggering thing. At that time, it was $275,000. That was the big up, and then eventually went up to $600,000 and stayed at $600,000 for quite some period of time, and now has gone up from there. So that's what inflation's done over the last 30 years. So,
I'm reading material that was written talking about things that were done back in the 20s and so forth, and how this is actually by a life insurance person. His name was Frank Vecher. And anyway, when he put a $100,000 life insurance policy in place, that was a big deal. And it was probably like putting, maybe $5 million into effect these days, or maybe more. I don't know, but anyway, it was huge.
Well, yeah, I kind of giggle because if you go back in the 1970s, when I started practicing law, you could buy a nice house in Palo Alto for $35,000, and that same house today is worth 100 times that. So, so it is. That's what inflation has done, and we're in our particular area.
Especially in our area when we talk
especially in
about
our area,
real
real
estate.
estate, it's even worse. But but it isn't. It is. It's just what it is. But it does give us. The other statistic that's been out there, and I think this is probably accurate, that for a married couple, the $10 million plus exemption it means that something less than 0.5% of the population is going to get exposed to actually having to pay an estate tax. So the tax component of it is much reduced. It's still there for larger net worth individuals and families, but they're still, our tools are still there. One of the other interesting little factoids of all this is there were some other proposals floating around in last year and the year before to, quote, plug loopholes. And the loopholes they were talking about plugging were getting away from valuation discounting, which is a significant aspect of what we do.
Right.
The other one was to make GRATs, which is a very effective tool for transferring wealth, especially in our community.
Okay, it's a grantor retained annuity trust.
Grantor retained annuity trust, which allows a grantor or a donor to transfer the upside value of a stock to children and grandchildren, basically estate and gift tax free. And we use pre-IPO stock to do it. You get a pre-IPO stock that's worth $1 and it goes to $30. You can basically take that $29 upside and give it to the kids under a GRAT. And one of the things they were talking about was having a minimum 10-year term on a GRAT, which would have significantly reduced our ability to do that. So that wasn't in there either. So we had no GRAT rules, no valuation discount changes. So that was the interesting thing there.
Okay. So when we say permanent, the good thing is, again, no automatic phase out as we've had in the past, where we've got this cliff situation, particularly related to tax rules. But Congress can always make other changes. There has been talk about tax reform. The president, so folks, it's January 22nd, you'll be seeing this sometime later. But so yesterday was Inauguration Day, and President Obama talks about tax reform. And so there has been talk in Congress about it. My feeling, though, is after watching what's happened since Mr. Obama has come into office, is it seems like you've got to really push these guys close to over the cliff in order to get them to do anything. And I don't see anything urgent coming up like that. So actually, I don't expect any major tax legislation, probably for the rest of Obama's term. I don't know if you have any feeling or not.
I don't have any idea one way or the
The
other.
crystal ball's broken.
Yeah, my crystal ball broke a long time ago.
There you
So
go. Okay, well, let's get into this last little point that we talked about. What if a gift was made during the last couple of years? You know, all these people were stressed out, whatever, and then so they got pushed, feel like they got pushed, and now they say, well, maybe I didn't really want to do that after all. So what can they do about that?
Well, there are a few things. We fortunately have only had a couple of people inquire about it, and both of them were basically planning that we did not do. Somebody else did it.
Okay.
And they're looking to undo it. There actually are there are three main devices that we have, and one of the easier ones, which a lot of people did do, and that was that they decided to give away the principal family residence to take advantage of the at that point $5 million gift. And when you give away a piece of property, you give its basis.
Yes.
And these were long-term held property, so the basis was low. And if they had waited and had it pass through their estate, they would have got a step up in basis and save a lot of capital gains tax for the family.
So folks, for our viewers, a basis means it's like the cost that you used when you're computing gain or loss on your tax return.
Correct. And one of the ways to solve that problem is that it's sort of flip our normal way of doing things. When we make gifts of property like that, we want to make sure there's no retained life estate. And the retained life estate is living in the house without paying rent. If you do that, that's a retained life estate. And if there's a retained life estate, then the asset is includable in your estate for federal estate tax purposes. So all you have to do is have the donor continue to live in the house, not pay rent, and it's includable in their estate for tax purposes. They may not own it, but it's still includable in their estate. And that will get you the step up in basis when the donor passes on. And then the other, this is lawyer talk, but The other thing you can do is what we call common law rescission. You can bring an action for rescission, and action means you're going to be in court to rescind a transaction on the
Undo
basis.
the deed.
Undo the deed, literally, and rescind the transaction. It's a lot more complicated, but it is a surefire way to get it done. Another little interesting technique is if I give you my house, okay, and you don't want it, you can decide I'm not going to accept it, and that undoes the deed too. You can not accept it, and you can then undo the transaction that way. So there are several tools out there available to us to undo it if the client wants to. But I don't think any of our clients that have done it, none of them have talked about undoing it. I think they're kind of glad that maybe they did it.
Yeah.
It was something they probably should have done, and they got pushed into doing it because of perceived, or not perceived, it was real, significant tax cost of not doing it. So,
Yeah.
so anyway, those are some of the tools we have as lawyers to make it work.
Great.
Okay.
Okay, Jim. Well, I don't know if you can note, but we've got about a minute here left. And so I think we've done a pretty good job of covering, you know, a complex area. We've got some really significant opportunities, and particularly for flexibility for those families that are under the 5 million. We will be talking about the portability, as I said in another interview, the next one. And so we'll get into it at that time. Meanwhile, though, folks, there is still need for estate planning. If you don't have a will and a trust, good idea. We're actually sitting here in the new year. You'll be seeing this maybe in April, but nonetheless, put it on your agenda for this year. Make that resolution to get it taken care of. We'll see you next time on Financial Insider Weekly.
Thank you, Mike.